Our firm represents a lot of clients on weapons and firearms charges, and we're always looking to get a charge dropped. I mean, that's the goal of any client, to get a charge withdrawn ultimately. And what are the ways and means of doing that? How can we get a firearms or weapons charge dropped? Well, first of all, weapons and firearms charges, it's the full gambit from a very minor charge, well, nothing's minor, but careless use or storage of a firearm, right up to use of a firearm in commission of offense, which that attracts like years in jail, unfortunately, with mandatory minimum multi-year jail terms. So our first goal is to try and get the charge dropped. Can we get it withdrawn? Well, the answer to that lies in the disclosure. We need to get the police reports, the witness statements, all of the videos, witnesses, you name it. There's going to be documentation that's provided to us. And when we receive that documentation from the Crown, I'm going to review it carefully, sit down, analyze it, figure out if the police made mistakes, if there's procedural errors, if there's an identity issue, if it's a weak circumstantial case. Is there a valid search? Did they have a good search warrant? Did they stop a person on the sidewalk for no apparent reason and found a weapon? Is there racial stereotyping? There's all sorts of defenses to these charges, and I'm going to find it if there is. And of course, I get cases where it's overwhelmingly strong case, and you're into just negotiating the most lenient possible sentence, hopefully avoiding a jail term, or at least minimizing a jail term if it's a serious offense, such as use of a firearm on a commission of offense. But I'm talking about a case where I see issues, I spot issues and problems with the Crown's case. So now, what do I do then? Well, I'm in a position now to provide the client with their legal opinion. So I meet with them, and maybe one or more meetings. They're going to want to review the disclosure too. I'm going to review it with them. I'm going to give them my legal opinion about the strengths and merits of their case and what I think I can do with it. Hopefully, I've found some problems, some flaws with the Crown's case, and I'm going to describe those to the client, receive their instructions. I'm going to say if there are some flaws, some charter issues, some legal searches, some technical problems, police errors, police didn't follow procedures correctly, invalid search, you name it. I'm going to discuss that with the client, receive their version of events, receive their background too, all of their personal history, because if you've got a good prior background, that's helpful in getting charges dropped if it's a weaker case. You know, the Crown's less interested in dropping charges against someone who has potentially multiple convictions on their record, or is a drug dealer, or things like that. But I'm talking about a person with a good prior record. So now I meet with the Crown, and if it's a mistake that can't be fixed, and that's a key, and many mistakes can't be fixed, I'll disclose it to the Crown and ask them to withdraw the charge. Look, there's no reasonable prospect of conviction. I've got to disclose charter issues to them. That's a requirement. It's reverse disclosure. I have a video about that, by the way, on reverse disclosure. Charter challenges do have to be disclosed, so you can discuss that sometimes technical flaws can be fixed by the police, so you have to be careful. You got to make sure it's one that can't be fixed before you disclose it, because if it's a powerful flaw, you might just want to go off to trial, because if they can fix it, that ain't any good. Believe me, that ain't good. So, and I think every lawyer in their career I've been practicing law for 33 years, and I'm sure at one point in my career I probably disclosed too much to the Crown on a particular case, and you'll only make that mistake once in your career, believe me. You don't make it after 33 years. So, what do? I go to the Crown and I discuss the case with them. I discuss my client's background. Look, you've got this hole in your case which can't be fixed. It was an invalid search. There's an identity issue. You've got a weak circumstantial case. And hopefully the Crown agrees with me. So what will the Crown do? Well, if there's no reasonable prospect of conviction, they should withdraw the charge. It's not in the public interest to continue any charge where there's no reasonable prospect of conviction. But what if there is some prospect of conviction, but the Crown says, yeah, you're right, you got a pretty good chance here. I think we should deal this. It normally requires a criminal record, but maybe I'll agree to a conditional discharge on a minor offense for no record. Sometimes they've even got charges diverted, like a serious charge of careless use of a firearm or carrying a concealed weapon because there was problems with the case. Diversion would be great. You get do some community service up front, maybe take some counseling for violence or whatever, or weapons, and get it withdrawn in court. I mean, that's a fantastic result on a weaker case. because there's still risk in going to trial. You don't want to go to trial and have even a 10% chance of losing. So there are weapons charges that we can get withdrawn. There are weapons charges that are weaker where the Crown's convinced to do a conditional discharge. Occasionally we can get diversion on a very weak case as well. So there's ways and means. I mean, these can be very serious charges, and you have to, as a lawyer, you have to do everything in your power to get the best result for the client. Avoiding a criminal record, and a conditional discharge avoids a criminal record, is often a great result. And I've had very serious weapons offenses where we had great results in this regard, including getting charges withdrawn, including getting diversion in one case, and in some cases conditional discharges where really the person should have gone to jail. But the Crown said, you know what, you're right, Mike, you've got a much better chance than winning than me, and I'm going to cut my losses here. So it's all about negotiation. It's all about having the knowledge and the expertise and know what the defenses are, being a good constitutional lawyer, knowing a client's rights about search and seizure, because a lot of these weapons cases are pursuant to search warrants in homes, pursuant to searches on the street or car, or in the context of a motor vehicle, personal searches. And a lot of times the police make errors where they didn't have reasonable probable grounds to search the person, or they did not set out proper reasonable probable grounds where you attack a search warrant. And we get the good result, and that's what the clients want. I mean, who doesn't want to get their weapons charge dropped? And that's our first and primary goal when we get your case and analyze your disclosure and then negotiate with the Crown. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.